Good afternoon, everyone, and welcome to today's panel discussion on the Supreme Court's decision in the Dobbs case and what it means for medical professionals. My name is Elizabeth Kronk-Warner, and I have the privilege of being the Dean at the S.J. Quinney College of Law. My pronouns are she and hers. And as I like to do anytime that we gather to have an important discussion, I do want to start off by acknowledging that the land that we here at the University of Utah are on is land that is named for the Ute tribe. It is the traditional and ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. The University of Utah recognizes and respects the enduring relationship that exists between many indigenous peoples and their traditional homelands. We respect the sovereign relationship between tribes, states, and the federal government, and we affirm the University of Utah's commitment to a partnership with Native nations and urban Indian communities through research, education, and community outreach activities. We're really pleased that you can join us today for what is the second of three conversations about the Supreme Court's Dobbs decision. So yesterday we started off with a panel on the impacts to potential future rights, such as same-sex marriage and contraception. If you're interested in that panel discussion, you can always find a recording on our YouTube page located at the S.J. Quinney College of Law website. And also we will be having another discussion during our annual Fordham debate later this month on the Dobbs decisions and future impacts. So we hope you can join us for that. But today we're here to talk about a really important and confusing question following the Supreme Court's decision, which is what is the impact of this decision on medical professionals? And so I'm really pleased that we just have a stellar group of panelists here with us today. And before I turn it over to my amazing and phenomenal colleague, the Dean of Nursing, Marla DeJong, I do want to just briefly give some context to today's panel by sharing what the U.S. Supreme Court actually decided in the Dobbs decision. So the Dobbs decision was decided on June 24th, 2022, as I'm sure many of you heard because it was definitely in the news. And central to this case, and I know we're going to hear more from Professor Francis, but central to this case was Mississippi's Gestational Age Act, which provides, and I quote, "Except in a medical emergency or in the case of severe fetal abnormality, a person shall not intentionally or knowingly perform or induce an abortion of an unborn human being if the probable gestational age of the unborn human being has been determined to be greater than 15 weeks." Now, Jackson Women's Health Organization, which was an abortion clinic, and one of its doctors brought a challenge to this specific act, Mississippi's Gestational Act, arguing that it was unconstitutional as it violated the U.S. Supreme Court's decisions in both Roe versus Wade and Planned Parenthood of Southeastern Pennsylvania versus Casey. The district court granted summary agreeing that the act did not comply with those decisions, as did the Fifth Circuit. So the Fifth Circuit affirmed the district court. So this case was then taken to the U.S. Supreme Court, and specifically the argument there was that the Roe and Casey decisions were wrongly decided and that the act is actually constitutional because it satisfies a rational basis review. Ultimately, as Dr. Francis will get into much more in depth later, the court held that the Constitution does not confer a right to an abortion and that Roe and Casey were overruled and that the authority to regulate abortion is returned to the people and their elected representatives, which means that it's up to state legislators to make the decisions, which then raises the question of what are medical professionals to do. So I'll now turn it over to my colleague, the amazing Dean Marla DeJong, who will introduce our panelists and talk about some of these issues. Thank you so much.
Thank you so much, Dean Kronk-Warner. I appreciate it. I appreciate all of those who have joined us for this important discussion today. So I'm pleased to introduce you to our panelists. First, Leslie Francis, who is the Alfred C. Emery Endowed Professor in the University of Utah S.J. Quinney College of Law. Next, Dr. Misha Pangasa, a board-certified obstetrician and gynecologist. She is currently a fellow in complex family planning, a subspecialty focused on complex contraception and abortion care at the University of Utah School of Medicine through the Department of Obstetrics and Gynecology and Division of Family Planning. Next, Dr. Jessica Sanders. She's an assistant professor at the University of Utah School of Medicine, Department of Obstetrics and Gynecology, Division of Family Planning. And finally, Dr. Sarah Simonson, an associate professor and the Annette Polson Cumming Presidential Endowed Chair in Women's and Reproductive Health at the University of Utah College of Nursing. Welcome, panelists, and thank you so much for engaging in this important conversation about what the Dobbs decision means for medical professionals. So I'm going to first turn it to Leslie, who will provide some additional context about the law, and then I'll return with some comments and provide an opportunity for our panelists to share some information with you and then be thinking of questions that you would like to ask our panelists.
So I'm going to share my screen because I find it helpful to use slides for this. And let me just, while I'm saying that I'm going to do this, I also want to say that one of the things the Supreme Court said in Dobbs was that they wanted to put an end to confusion and litigation about abortion. They haven't done that. And so some of the bad news I'm going to give you is that there's a lot we don't know. So I'm going to very quickly try to tell you a little bit about what I think we do know and what we don't know. So here's what the court said. As Dean Kronk-Warner indicated, no longer is there a right of the kind the court recognized in Roe. It's now up to states to decide how to regulate abortion at any point in pregnancy. State regulations are subject only to what's called the rational basis test, which basically means the state has to have any old reason, or maybe even any old reason that the court could attribute to the state. The court also said that no other rights are affected, at least no other decisions. As yesterday's panel emphasized, we'll see about that, but I want to mention some of them that might be in play for physicians. Justice Kavanaugh wrote a concurrence, that would mean it's 5-4 the other way if he sticks with it, to the effect that the Dobbs decision does not affect the right to travel across state lines. So that would mean state efforts to stop people from going out of state for abortions would be constitutionally suspect. There are other constitutional protections that I suspect will come into play. For example, the protection against unreasonable searches and seizures in the Fourth Amendment. The court assumed, for the sake of argument, in 1990 that competent patients have a right to refuse medical treatment. And there's the First Amendment, freedom of expression, that might protect physicians and other healthcare providers' conversations with their patients, including conversations about abortion options. There are other federal statutes, the Emergency Medical Treatment and Active Labor Act, about emergency treatment and the obligation to give it, and the Food and Drug Administration Act, which might preempt state efforts to intervene with medication abortion, something we just don't know, and the various state laws. So now, a very quick overview of what we have in Utah right now. And I'm emphasizing what we have in effect right now. The first is a statutory definition of abortion, which is, and the language is up here, the intentional termination or attempted termination of a human pregnancy after implantation of a fertilized ovum. I put that in green to emphasize no emergency contraception is included in this. No form of contraception that would affect implantation is included in this. And there are no implications for cryopreservation of embryos in IVF. Abortion is also not removal of a dead unborn child. So at any point that the fetus ceases to be alive, abortion is not at issue. And the statute also is specific that ectopic pregnancies are not included. So here's what's in effect. And the first one, the Attorney General said it went into effect and it was not the subject of the complaint or the order as far as I can read them, which is Utah's 2019 prohibitions for abortion when the healthcare provider knows that the sole reason for the abortion is Down syndrome, unless there's some other reason to permit the abortion. And we have a ban on abortions at 18 weeks, unless, and these are the four unlesses that show up also in the trigger law, which is currently not in effect. Abortions may be performed unless, and may not be performed unless, so they may be performed if avoiding the death of the woman, avoiding serious risk of substantial and irreversible impairment of a major bodily function of the woman. 2 maternal fetal physicians certify in writing a fetal defect that is, quote, uniformly diagnosable and uniformly lethal. I'll leave it to healthcare professionals to explain what that might mean, or a severe brain abnormality that is uniformly diagnosable. And here the statute defines that as a malformation or defect that causes an individual to live in a mentally vegetative state. And I will leave it up to medical professionals to tell me what that is too. And then rape or incest with a report that is confirmed by the physician. And if the physician has made sure that any abuse, for example, child abuse, is appropriately reported. So the trigger law currently on hold, again, abortion after implantation may be performed only if death, serious risk, fetal defect, rape, incest, appropriately reported and verified. And I'm done.
Thank you very much, Leslie. So as she explained, these new laws have led to confusion in terms about what healthcare providers may or may not do when caring for persons who are pregnant. The Dobbs decision has enormous implications for many, including a plethora of challenges for medical personnel as they balance providing evidence-based care, fulfilling their ethical obligations to their patients and the profession, honoring women's healthcare choices and basing healthcare decisions on sound clinical judgment, adhering to the law and wrestling with topics such as navigating interstate travel to seek an abortion, determining at what point a pregnant woman's life is in jeopardy, assessing whether a fetal defect is fatal, and maintaining patient privacy and protecting their health information. So, for example, as was said, state law can be confusing to navigate and it's changing constantly. Providers are concerned about criminal and civil liability and the tension between state law and Federal Emergency Treatment and Labor Act requirements. Pharmacists are navigating new territory and sometimes vague laws about dispensing medications that induce abortion, especially across state lines. Faculty wonder whether they may teach students about abortion care, and nurses, nursing and medical assistants wonder whether they could be considered as aiding in an abortion and therefore also criminally liable. Our panelists will discuss important considerations for medical personnel. They're each going to provide some brief information, and then we will allow ample time for questions and answers. Please add your question to the Q&A box and know that we will get to as many as possible and that we will not disclose the information of who asked the question. So we will begin with Dr. Pangesa, who will provide comments from her perspective as obstetrician and gynecologist and expert in complex family planning.
Thank you so much. So as you mentioned, I'm an OBGYN, and I have had the privilege of practicing obstetrics and gynecology in New York, Pennsylvania, Massachusetts, and Utah, all prior to the Dobbs decision. I came to the University of Utah in 2021, and I had about a year here prior to the Dobbs decision. And one of the most notable things that I'm not sure that most people realize is that Utah was nearly post-Roe even prior to the Dobbs decision. There were already over 30 laws restricting abortion care, making it stigmatized, siloed from normal obstetric healthcare, and significantly restricted to the extent that even when legal, many people who needed or wanted abortion care were still not able to access it, even when it was technically legal. So since the Dobbs decision, I would say that the biggest changes on the ground that have happened are, as mentioned just now, we now do officially have an 18-week ban in place. And it is true that the majority of abortions do happen in the first trimester, but pregnancy complications that sometimes result in unexpectedly requiring abortion care often don't happen until after 18 weeks. And since this 18-week ban has been in place, it does felonize physicians for performing abortions that don't meet those legal definitions of the exceptions. And, you know, Professor Francis said she'll leave it to the medical professionals. The language used in these legal statutes is not based in medicine. These are somewhat arbitrary language, but it's left physicians and care providers to decide whether or not their patient's clinical scenario meets these legal requirements. And if they jointly with their patients decide to proceed with ending a pregnancy, every provider is now essentially forced to make a risk calculation. How likely is this patient to actually have an adverse outcome if I provide this care? How likely if I don't provide this care? Am I liable for malpractice if I don't act? Can I be criminally charged if I do? And you know, just to reiterate what has been said already, as physicians and care providers, I did not go to law school. Since the Dobbs decision, I've had several conversations with lawyers and legal experts, and in 2 months have learned the incredible amount of complexity that the legal system has. And despite all those conversations, the conclusion I've come to is that it's just very confusing and it's changing all the time. And it's often a question to legal experts, is this thing, if we provide this care, is that legal? If we do this, is that legal? And a lot of the times we still don't actually know the answer. But what we know is that, you know, in history, when medical malpractice laws change and that risk calculation changes, it most certainly changes the way that providers deliver care in terms of being more conservative. And with the risk of criminal prosecution, the real dangling threat of being prosecuted or felonized and jailed is certainly going to shift the standards of care that physicians provide. But I do want to mention that since the Dobbs decision, one of the things that has been the most reassuring to me is just seeing the intense, robust communities of care providers, policy experts, people throughout the Utah community that are committed to making sure that the people of the state continue to receive the best care. Some of the panelists here are part of that. All of the panelists here are part of that incredible community. And that has been reassuring to know that we'll continue to try to protect our patients, protect our providers, and continue to try to do the right thing, even in the face of, you know, potentially very restrictive and quite frankly, scary legislation.
Thank you, Dr. Pangasa. Now we'll hear from Dr. Sarah Simonson, who will share her perspective as a certified nurse midwife and family and preventive medicine expert. Sarah.
Thank you. So I would like to talk a bit about what non-abortion providers can do to support individuals at risk for unplanned pregnancy. And I think the thing I want to start with is the importance of providing comprehensive, client-centered contraceptive care, making sure that all contraceptive methods are made available. There's been a nice transition where we no longer are pushing certain methods over other methods. We really want to make sure that clients make informed decisions about the right methods for themselves. And I would like to make a plea that we don't start pushing long-acting methods on people just because we're worried about their risk of pregnancy, that we offer full comprehensive care. I think this is especially important for individuals of color who have a history of forced sterilization and reproductive coercion, I guess. So really making sure that our clients at risk of pregnancy have a full range of options available. I want to talk a little bit about emergency contraception, which is not affected by the current law. We should be promoting emergency contraception and offering advanced provision of this for individuals, even individuals who have another method that they're using, because inconsistent use can happen. So for people to have emergency contraceptive pills available to them could be very important in preventing an unplanned pregnancy. Right now, Plan B, there are two types of emergency contraception, Plan B and Ella. Plan B is available over the counter, but people have been stocking up on this. And it can be more expensive over the counter. So consider prescriptions for Ella or for Plan B for folks to keep on hand so that if they need this, they can fill it or have them fill it and have it available in case of need. Also, there are two methods that can be used for emergency contraception, the copper IUD and the hormonal IUD. And I think we should be aware of that and making sure patients are aware of those methods that can both be used as emergency contraception and then can be used for a long-acting reversible method. Another thing I felt is important to share is that Utah pharmacists can actually prescribe self-administered hormonal contraception directly. And right now, Smith's and Associated Food Sites and Dan's are offering this. And there's a number of other sites throughout the state that are working on this, working this into their workflow. So people should call ahead to the pharmacy to see if this is available, but it's a way that those at risk of pregnancy could directly access contraception without seeing a healthcare provider. It's really important that if a patient does have a positive pregnancy test, we can provide comprehensive options counseling. It's appropriate, it's legal. That includes referrals to Planned Parenthood, which is still doing terminations up to 18 weeks, and the Utah Abortion Fund, which can help individuals navigate their healthcare needs. There's also some important policy work ensuring that women with Medicaid covered births retain coverage beyond 60 days postpartum. It's really important to help improve health outcomes, and that expansion of Medicaid beyond 60 days has been shown to increase contraceptive use and long-acting contraceptive use in postpartum women. Also supporting the Medicaid family planning waivers to expand coverage of family planning services to more Utahns is important right now. Finally, I want to put in a plug for the contraceptive skills training that the Ascent Center is putting on September 30th. We'll put some information in the chat about that. And also to refer folks to a website, Family Planning Elevated, that has information on all of the different methods of contraception if people need a refresher on different methods.
Thank you so much, Sarah. And from a policy and non-clinical sexual and reproductive health research perspective, Dr. Jessica Sanders, please share your thoughts with us.
Hi, thank you again for having us today. I'm going to share my screen, so bear with me. Okay. So one of the things that Dr. Pangasa brought up is that there is, a coordinated approach to how we are thinking about this and how we are discussing a post-Roe and post-Dobbs Utah. And one of the things that we are working on and with is a post-Roe task force. So we're approaching this with kind of the general charge of preparing for, documenting the impact of Utah's abortion ban and loss of abortion care services, supporting clinical guidelines and communication channels that mitigate patient and provider risks, that adhere to Utah laws and medical standards, and our values aligned to the University of Utah's mission and commitment to patient care and community health. And ensuring that all of this is we're using an equity lens applied to all planning and partnerships as we move through this kind of new landscape. As part of the post-Roe task force, we have kind of divided the areas of consideration into 7 subcommittees, including clinical care and clinical education and training, campus community and understanding how these impacts kind of trickle throughout the community, public education, communications and engagement, as well as data collection, monitoring, and research. So this is another big component of the work that we're doing here. Legal guidance, which things like today are really important in kind of having that ongoing communication about the legal landscape, and provider advocacy and understanding ways that healthcare providers can provide evidence and experience into these conversations. So one of the resources that I want to stress, so the main thing that I want to communicate during this time is that there's an abundance of resources available, and we're continuing to update them and respond when necessary with new resources. But one of the resources that's available to you all and to our state more broadly is the Ascent Center for Reproductive and Sexual Health. So the Ascent Center is a newly established multidisciplinary collaborative at the University of Utah Health Sciences. While the center is newly established, our team has been working in this area for over a decade. So it's definitely a time of growth in our community, but and the hope is that we will support and promote sexual and reproductive health equity through direct service provision, research, and education for all individuals in the Mountain West, and becoming a unique regional resource for reproductive and sexual health rights and justice is one of the primary goals. So I wanted to just highlight some examples of the work that the post-Roe task force has been doing. This provider advocacy component of aligning the messaging from providers with medical standards has been an important part of this work. And so this piece came out in newspapers across the state, including the Trib and the Deseret News, as well as a newspaper in every county in the state, with a kind of a joint message to patients. And while not explicitly representative of the University of Utah's views, this is providers speaking on their own behalf. It I think showed solidarity and kind of consistent language with medical experts across the nation. So it was an exciting thing to see, and I think really moving, and I think an important message to see that so many providers in our state are supporting comprehensive sexual and reproductive health care, including access to abortion services. Dr. Simonson mentioned the expanded contraceptive access piece, and as of yesterday, I mean, this is like things are happening fast. There's a new button in my chart that allows for people to schedule a rapid access to contraception appointment with trained providers and providers trained in person-centered counseling, which I think is a really exciting transition to say, we know that we've needed to remove barriers to accessing contraceptive care. And we're really committed to this right now. And I mentioned a number of other resources available, but these include the Assent Pulse page, as well as dot phrases that can be used in clinical care. Abortion Access Utah Patient provides patient information on the current landscape of abortion care, as well as general information about self-managed abortion and other different resources across the state. And then family planning resources broadly is also another dot phrase that can be included. I mentioned the post-row provider resource list, and these are links that are all available in the Assent webpage, and again, are updated regularly. So as things change, but can be really helpful in kind of thinking through, as a provider, the different questions that you might have and frequently asked questions. We also have worked with the Office of General Counsel to put together guidelines to support U-affiliated clinicians and scholars in engaging as patient advocates or scholars engaged in policy-related research that are consistent with kind of the Regency guidelines and kind of understanding, when you're speaking on behalf of yourself, and when you can share resources like that have been generated through the university. And then I posted a brief QR code in some of the work that the Network for Healthcare Advocates for Reproductive Policies and Rights, and that's another space to continue this conversation and join in. And we also have our upcoming trainings that Sarah mentioned, and a family planning on call. So if there are specific questions that come up in clinical care, our team, like Dr. Pangasa, are there for you as we navigate this kind of confusing and new landscape. So I hope that those items are helpful, and I look forward to engaging in a robust conversation.
Thank you so much, Dr. Saunders. Appreciate it. Now we have a good amount of time for questions. And so thank you for those of you who have submitted questions already. Again, just a reminder, you can go to the Q&A button on the bottom of your screen and type in a question. And I will go through, read the question, and then direct them to those panelists who I think are best prepared or able to comment on the question, but invite others to participate as well. So the first question is, the abortion definition looks to apply only to physicians. Does that mean that other healthcare providers, such as nurse practitioners or physician's assistants, could technically be excluded from this definition and that the law does not apply to them? Leslie, I think this is a perfect question for you.
Sure. When you read the entire statute, and of course I was just trying to cut to the chase, you're right about that. But there's another provision of the Utah Code that says that abortions may be provided only by physicians. So if a non-physician were to perform any abortion for whatever reason, they'd run afoul of that. So this is not it's not a free pass.
Thank you. And the second question, I believe, is appropriate for you also, Leslie. Someone said, I'd love to know how the prohibition against termination due to Down syndrome is to be enforced. How could it be determined that the diagnosis was the main reason for interest in termination among so many other possible considerations a pregnant woman might have?
So that, I'll make it even worse. It has to be physician knowing that the sole reason is Down. And of course, when people have abortions, they have abortions often for complex reasons that would not be a sole reason. Now, that said, anytime you've got a criminal statute, states got to prove each element of the crime, including the mental element and the physical element or the material element, beyond a reasonable doubt. And one of the things that I think is just so hard here is that people don't know what kinds of cases prosecutors are going to bring, and that's scary. I think a prosecutor wouldn't get very far, but you never know what somebody's going to try. And part of that, I think, and this I'll leave up to the medical side to comment on, I think you want to be very careful about how you document care in the chart.
Thank you, Leslie. And I'm wondering, any of the other panelists care to add comments to that question? Nope, I don't think so. Okay, thank you so much.
I would like to add one thing that when the first question, actually, when it was talking about the provider side, I think one of the things, like, when we keep our kind of ear to the ground on what's happening in other states, this broader criminalization is something that we should be paying attention to, and being vocal about, where healthcare providers come down on it. And I think that that's something that we will see kind of what happens playing out, but just keeping an eye on what other states are seeing happen with the language around aiding and abetting, or even criminalization of the pregnant person, and the various ways that can play out. And hope, we hope that it doesn't, but even in places where it's kind of watching what the prosecution side of things do. So it's not benign, but that was, the one place. And then I think with the HIPAA and the documentation side of things, we've been thinking about kind of the role that HIPAA plays. And that's another place that as providers, we can protect patient information, but also the importance of knowing the harms that can come with reporting. So this is not a place where providers have mandatory reporting around abortion care. So if there is some, if a patient discloses that they self-manage their abortion and you're treating them, wraparound services for continued cramping and bleeding, or they have concerns, which treating for wraparound services is absolutely legal and important, I think, and will continue to be an important part of the care that you're able to provide here in Utah. But that it's not only is it not required, but there's evidence that shows that it's detrimental to health when patients do report. So just considering that as we move forward.
And HIPAA is tough here because there's a HIPAA exception for law enforcement. So that's going to be something, again, that people are going to have to work out over the next few years, or maybe more than that.
I just want to add from the provider perspective that absolutely documentation in the chart is something that I have thought more about recently than ever previously. And while a lot of the times in the provider sort of networks, we're talking about what we write in the chart and thinking about protection of providers, I think it's really important to recognize that the electronic medical record and charting has been used to criminalize patients primarily. And so, as we're thinking about what we're writing, it's not necessarily a risk calculation for ourselves as much as the patients that we're protecting.
Thank you, Misha. I think the next question is for you, Misha. Will there be any impact on malpractice insurance for healthcare professionals? Will insurance cover legal action by the state or individual under the Utah statute described by Professor Francis?
So I'll answer that to the best of my ability, which is, as a provider asking these questions, malpractice insurance does not cover criminal legal funding or anything like that. And, all of us who come in to practice medicine end up getting some sort of malpractice insurance in the various places that we provide, but that does not cover criminal prosecution, which is a separate kind of boat altogether. And I can say that, conversations with leadership throughout the University of Utah have sort of given us reassurance about having that protection through institutions, but that is certainly not true for people who are practicing outside of larger institutions. And it's still something that, quite frankly, just it doesn't fall under the typical malpractice that we're all used to providing under, and having some sort of reassurance and safety under. And it absolutely, because the criminal system is just different than the malpractice system, I think it is going to impact the way that people make risk calculations and the way that they deliver care.
Another question, Professor Francis listed some of the exceptions to the Utah abortion ban. Assuming a ban with exceptions stays in place in Utah, what are some important exceptions that you as panelists feel might be missing?
I'll jump in on one of them. I think that the exception for fetal anomalies is poorly defined and very, very narrow. Because, let's take a condition like Tay-Sachs. I would assume that babies born with Tay-Sachs die within the first year of life, or maybe not any much longer than that. But is that uniformly lethal? Nobody knows when. Does that mean would die at birth? The idea that really the only fetal anomaly that counts is mentally vegetative. I mean, conditions, neural tube defects, even anencephaly, it's not all or nothing in many cases, as I understand it. And so that's that's one of the places that I'm particularly concerned about, the misfit between what the statute says and what medical practice in real life looks like.
I want to say two things. First, just to recognize that I think the exception system, the framework in and of itself is flawed, and trying to capture all of the indications why people might need to have abortions in exceptions is in and of itself problematic. But just to echo what you said, the vast array of pregnancy complications that we see, from structural abnormalities, genetic disorders, that it is impossible to predict mentally vegetative state on a prenatal ultrasound. And so trying to counsel patients about, abnormal ultrasound results, abnormal genetic testing results, and what their options are is a huge missing piece of that legislation. And then the other one, which I think has come up in another question, is about rape and incest that must be reported to law enforcement. And typically as providers, that to us means, do we know that have we verified that there's a police report, that the patient who is seeking an abortion has contacted law enforcement and has a police report saying that they have, reported this, and whatever other investigation has to undergo. But that is a huge, huge barrier for victims of sexual assault and rape. And so I think that that's a major issue with the legislation that we have.
Thank you. This question was addressed at least in part, and it has to do with the timeliness of accessing IUDs as emergency contraception, for example. So I know there was a slide about ways to receive more timely access. There's something new in my chart. Anything else that you panelists would like to add to that? And I think it's terrific that that's been a priority, realizing that access to healthcare is exceedingly important in some of these situations. And so
Could I chip in something here? I have a wonderful honor student. Her name is Kylie Ferret, who is looking at what other universities are doing around the country. And there are several universities now that have, Kylie just told me yesterday, vending machines for Plan B.
Yeah, so the vending machine thing is definitely something that our university has looked into as well. And we this last year did the campus contraceptive initiative, which removed out of pocket cost to any contraceptive services. The EC access is something that we are continuing to improve. As many people know that, Plan B is available over the counter, but there is oftentimes a cost barrier associated with it. So removing those costs, specifically at University of Utah pharmacies, is something that we are actively working on through the Family Planning Elevated program. And with regard to the quick access to IUDs as EC for folks who are interested, that is something that we've worked on, in the research side of things, and published a paper in the New England Journal of Medicine on the levonorgestrel IUD for EC, and finding that it is an effective form. And so that's something that our work with Planned Parenthoods here in the state and is ongoing, as well as an ongoing study looking at the implant for EC. And so expanding access to those long-acting methods that can be used, quick starting or as EC, is something that is continuing to be a priority. And so certainly through the MyChart, as well as our community health clinics, including Planned Parenthood, are great resources for those services.
Thank you. Someone mentioned hearing concerns about individuals who experience a miscarriage being accused of having an illegal abortion. So from a medical perspective, is this a potential problem? And if so, what would you like to share about that?
So, I think that that's something that's definitely seen in other countries around the world. There are places where people don't get D&Cs for miscarriages because of provider concerns about it being misconstrued as an abortion. And there are certainly states in this country where pharmacists aren't dispensing misoprostol to manage a miscarriage because they're afraid that they're actually contributing to, the management of an abortion. The management of an first trimester miscarriage and the management of a first trimester abortion look clinically the same, absolutely similar. There is virtually no way to really distinguish the two. And so while, I as a provider and all of my colleagues encourage people to continue to provide, evidence-based care for first trimester miscarriage, because that is not involved in the law at all. Again, what I said before, when you start dangling criminal felonies in front of people, it's just going to change the calculation for some people. I hope that all of the people who already are providing first trimester miscarriage care will continue to do so, because it's not involved in the laws right now. But I think it is a reality to know that in the United States as a whole, we will see a shift in that based on the just fear of prosecution.
What are your thoughts about a Utah provider providing resources for, or even helping to organize out-of-state abortion care? So this idea of referrals or providing information about where one could seek abortion care in another state. Thoughts about that?
I'm sure that Professor Francis can speak to the legal side of this, but these are, like, sharing of information is protected. Providers being able to, say in general terms where you can access abortion, providing information about abortionfinder.org or the Utah Abortion Fund as places to help support accessing abortion across state lines, including, pregnancy, like Dr. Sarah Simonson said, about options counseling during the visits, or even ultrasound dating. And those referral networks, I think, are something that are going to have to be strengthened at some level when we start, dealing with folks for fetal anomalies or these other issues that might arise that don't fall into the Utah code. And so right now, it's something that should be protected and should happen as in terms of high quality care, being able to provide pre-abortion services as well as post-abortion services if someone comes back to Utah and needs that type of health care. So I think, being able to practice the highest of your skill set within the bounds of Utah law is something that will continue to evolve, and something that should be a priority for healthcare providers.
I'll go back to the statutory definition of an abortion, which is the intentional termination or attempted termination of human pregnancy through a medical procedure carried out by a physician or carried out by a physician or through a substance used under the direction of a physician, etc. So counseling patients about alternatives is not included in that definition.
And I just want, sorry, go ahead.
I mean, if the legislature changed that definition, and some states are doing that, putting in aiding and abetting and other, that's the reason I put freedom of expression. And there's a lot of complicated jurisprudence about whether there's special protections for professional communication. Probably not in this case, but there's freedom of expression there too. So, how far states could go, we don't know, but our state hasn't gone there yet.
And that's evident in our on the ground work. Prior to the Dobbs decision and after the Dobbs decision, we certainly have had to send patients out of state to other abortion care facilities for various reasons, and more so after an 18-week ban. And those networks are in place and will need to be strengthened should we see worsening legislation.
Someone thanked the panel for an excellent panel presentation and just wanted to seek some clarification about the trigger law. So we'll just be clear. Is that already considered law now? And if not, what is the time length or process before it would become legal? In other words, do we have any recourse to keep it from being legal? So
it is currently enjoined, is the fancy legal word. It's not in effect. The state is, the normal legal process would be then for a full dress consideration in the trial court of whether the statute is consistent with Utah state law. This is a state law question, the Utah Constitution, not a federal question. So we'd see that in state court. Now, whether it's going to, and that could take at least a year, whether it's going to play out that way, we do not know, because the state is seeking what's called an interlocutory appeal to the Utah Supreme Court to get a ruling on the injunction before there's a full dress trial. So you may be familiar that the Supreme Court let the Texas statute go into effect while everybody's sorting out whether or not the Texas statute passes legal muster. So that could happen here, in which case, in a few months, the trigger law would go into effect, but it's currently not in effect. We don't know for how long.
Thank you. And I think this next question gets at that. I don't know if there's anything you might want to add to that, Francis. Is there any way for a physician or an organization to challenge the statute for vagueness without waiting for someone to be charged or prosecuted?
So you've got a legal distinction here, which is whether it's problematic or unconstitutional on its face, which basically means in any way it could be interpreted, it's out of here, or as applied. And my own best guess is that what's going to happen are test cases, which would be on the as applied side. But I don't know. And I see Jessica looking, might happen. I mean, that's why I point out some of the problematic statutory language like uniformly lethal and some of the ways that the statutory language doesn't fit well with medical understandings.
I mean, I think that's something that's come up a number of times, right? Is like the language that's used are not medical terms, and kind of figuring out that balance between the vagueness as an important feature in making medical diagnoses and having those applied, the applied piece as well. And like Dr. Pangasa said, though, the like individual risk balancing that will have to take place, and that could create some chilling effect and decrease the quality of care that people are able to provide, or change the standard of care that people have access to in our state. And I think those are all things that we should be really concerned about. And and that's as a researcher, one of the things that we will be paying attention to as we look at data in the months and years to come.
So we are fast running out of time. I think we'll do 2 more questions with, I think, relatively brief answers, and then I'll provide a couple closing comments. So this question's for you, Sarah. You discussed the miscarriage abortion issue we did as a group. Someone is interested in your perspective on the impact to midwives who might experience a stillbirth or complications leading to death at or around the time of birth.
So I would say this is in line with what Dr. Pangasa said about the miscarriage. So the management of that is not management of it's not an abortion. So that care should be legal to provide, and providers should follow the best evidence and the best practices. I don't know if Dr. Pangasa wants to add to that.
Yeah, just to echo the same thing, we should continue to provide that care. It is protected under the laws, but it's still going to make people afraid.
Yeah.
I also was thinking about the training that people will have access to for management of those cases. Those will be fewer and far between. So the quality of healthcare provider knowledge and experience around those things will be impacted by this legislation, and as part of the fallout as well.
Okay, last question. Someone has observed in history a reluctance of healthcare professionals and academics in their individual capacity to get involved in politics. Will this decision change that with a significant increase in public visibility among individuals who are healthcare professionals and individuals employed in academic settings?
I will just say that over 1,000 licensed healthcare professionals signed on to the letter that was published in the Deseret News and the Salt Lake Tribune. I'm relatively younger in my career, and maybe it's the networks that I'm in, but I see a lot of energy within healthcare professionals as a whole to be more active. And I think it's not just the issues related to abortion. COVID-19 created a whole new world in which people understood the implications of politics in public health. And so I think that we will see a greater energy there. And we did see it when we published those advocacy pieces.
Thank you. Just a couple quick closing remarks. Thank you so much for joining us for this important conversation. The public, which includes healthcare professionals, of course, shares the complete spectrum of beliefs and opinions about abortion care, which is, as we have heard over the past hour, a complex topic. I will say that University of Utah Health has determined that it will provide legal protection and indemnification and defense against liability for its providers who care for patients within the scope of the law, but who are accused of breaking the law. There'll be much more information in the weeks to come about that. Also, UHealth is going to ensure that students, residents, fellows receive the education required and the training experiences necessary so that they can provide abortion care and meet those learning competencies. And that includes the university paying for the cost that it might take someone to go outside of Utah to receive that training. Work is also underway to explore options to provide more accessible, comprehensive, no cost or affordable contraception, as has been mentioned, as well as expanded women's health care under Medicaid. And UHealth medical professionals will continue to advocate for evidence-based interventions. We'll continue to conduct research so that we can achieve our goal of improving healthcare for all. So I thank all of the panelists so much for engaging. This has been a very informative discussion. Thank you, and we wish you all a good afternoon.